On a sunny Southern California afternoon in March 1996, the Marines working on the night shift in Marine Aviation Logistics Squadron 39 prepared for their uniform inspection. As colleagues made sure they had the right covers, that their shoes were clean, and that everything was lined up the way it should be, Sergeant Jessie Quintanilla prepared a little differently. He donned his coveralls for work, drank heavily, drove to work, and walked into the executive officer's office, concealing a pistol. This is Conduct Unbecoming. I'm Erin, and I'm your host. Jessie Quintanilla, a native of Guam who grew up in Long Beach, California, joined the Marine Corps in 1989 when he was 21 years old. He had a new wife and a baby on the way, and the Marine Corps offered him an opportunity to build a life for his growing family. In 1996, Sergeant Quintanilla was assigned to Marine Aviation Logistics Squadron 39, a maintenance group at Camp Pendleton, just north of San Diego. He worked in the supply section of the squadron, on the night crew. The night shift is tough anywhere, but Quintanilla got into a routine of reporting for work in the mid-afternoon, right around the time his son would be getting home from school. At the squadron, his commanding officer, or CO, was Lieutenant Colonel Thomas Hefner. His executive officer, or XO, was Lieutenant Colonel Daniel Kidd. Quintanilla was one of about 600 Marines working in the squadron, and likely wouldn't have had much interaction with either the XO or the CO. Perhaps this is even more true for Quintanilla, who showed up, did his job, and had a spotless Marine Corps record. He had never been disciplined, so he didn't really have a reason to show up in front of either the XO or the CO. On March 5, 1996, the XO, Lieutenant Colonel Kidd, set a uniform inspection for the night crew for 1300 hours, or 3 p.m. The CO, Lieutenant Colonel Hefner, was changing into his dress uniform to prepare for the inspection. Lieutenant Colonel Hefner was changing in a small dressing room located next to the XO's office, Lieutenant Colonel Kidd's office. Inside the XO's office, Lieutenant Colonel Kidd continued his work. Quintanilla drove himself to the squadron in his coveralls, though he'd been drinking before work and was, by his own admission, drunk at 2:30 in the afternoon. Quintanilla, his wife, and their 7-year-old son lived in Riverside, but I couldn't uncover if this meant they lived in the city of Riverside, a 1-hour drive away from Camp Pendleton, or somewhere a little closer, like Temecula, which was in Riverside County and only 31 minutes away. I hope, for the sake of mid-afternoon school traffic, it was at least the shorter drive. Quintanilla arrived at the squadron, parked his car, walked inside, and went upstairs to the command suite. He waited until other Marines left, then entered Lieutenant Colonel Kidd's office at approximately 2:50 p.m. He later said he just wanted to talk to the XO about his family and financial problems in advance of the uniform inspection. But Quintanilla had something with him that definitely wasn't part of his uniform: a .45 caliber pistol tucked inside his clothing. The Marine Corps didn't issue .45 caliber pistols anymore. They'd been phased out in favor of the 9mm. This is all to say Quintanilla's .45 was privately owned. It was not a weapon of opportunity or something that he was required to carry as part of his uniform or to do his job in supplies. He and every other Marine on base was required to register any private weapon with the base, and he could not conceal carry on base. Instead of discussing the family or financial issues he faced, Quintanilla confronted Lieutenant Colonel Kidd in his office and asked, "Remember me?" When Lieutenant Colonel Kidd saw Quintanilla and the pistol leveled at him, he tried to exit his office into the changing room, the closest available exit that wasn't covered by Quintanilla and his pistol. Quintanilla pulled the trigger and his first shot entered the right side of Lieutenant Colonel Kidd's lower back, exiting the right front side of his abdomen. After exiting his side, the bullet amputated Lieutenant Colonel Kidd's right ring finger. Lieutenant Colonel Kidd stumbled into the changing room where Lieutenant Colonel Hefner was still changing for the inspection, with Quintanilla following just behind him. Quintanilla found an opportunity and again raised his pistol. He shot Lieutenant Colonel Hefner in the chest, though Hefner was able to run from the command suite. Lieutenant Colonel Hefner stumbled down the hall, then down the stairs, and finally exited the building where he was able to receive first aid from his Marines. He was lying on the ground just outside one of the building entrances. After Lieutenant Colonel Hefner ran from the changing room, Quintanilla turned back. He changed his focus back to Lieutenant Colonel Kidd. He pulled the trigger a third time, shooting Lieutenant Colonel Kidd. The bullet entered his upper back. Lieutenant Colonel Kidd collapsed and quickly bled out. He was just 40 years old at the time of his death in 1996. Quintanilla left the office suite and followed the trail of blood Lieutenant Colonel Hefner left. He passed a gunnery sergeant and a staff sergeant who were talking in the halls. Quintanilla raised his weapon, pointed the pistol at each of them, but did not fire. Downstairs, where the Marines tried to stop Lieutenant Colonel Hefner's bleeding, Gunnery Sergeant Tiller heard someone ask where Lieutenant Colonel Kidd was. While their CO lay bleeding, they wondered where their XO was, whether there was someone who could help. Gunnery Sergeant Tiller followed Lieutenant Colonel Hefner's blood trail back upstairs to the second floor. Upstairs, he found Quintanilla in the hall, blocking his way back to the command suite. Gunnery Sergeant Tiller moved towards Quintanilla and reached for the gun, which Quintanilla raised and fired a fourth time. Gunnery Sergeant Tiller avoided the shot and struggled with Quintanilla. He was eventually able to wrestle the gun away. Quintanilla broke away from Gunnery Sergeant Tiller and went back downstairs to an interior office. Inside, a number of senior enlisted Marines worked together, oblivious to everything that happened upstairs. When Quintanilla entered, he demanded they apprehend him. He said, "I shot the CO and the XO." Gunnery Sergeant Sullivan asked Quintanilla to sit down, which he did. Quintanilla talked with the Marines present, explaining why he shot the commanding and executive officers. He said he wasn't treated well in the squadron and that he did it for, quote, the brotherhood and the brown side. He warned, "This is just the start, and there's more to come." Later in their conversation, he pulled his coveralls down, removed his undershirt, and showed off his tattoos. One of the large ones read Sureño. Prosecutors believed this was in reference to the Sureño street gang. A base spokesman in the aftermath of the shooting and murder said they believed it was possible Quintanilla's name may have surfaced in connection with gangs, though it seems a little unclear whether this was something that genuinely happened before the shooting, or if this explanation came together after the discovery of the Sureño tattoo. Gang affiliation is grounds to discharge someone from the military or to reject a re-enlistment application. Back in 1996, Camp Pendleton maintained education campaigns for Marines and their families about the dangers of off-base gangs. This is my opportunity to remind everyone that on-base gangs aren't such a hot idea either. Other explanations offered for the shooting rampage include that Quintanilla was angry at a poor fit rep and that he was denied a spot as a recruiter. I suppose the poor fit rep squares a little better with the question Quintanilla asked Lieutenant Colonel Kidd, if he remembered him. First responders took both Lieutenant Colonel Kidd and Lieutenant Colonel Hefner to the base hospital. Lieutenant Colonel Kidd was pronounced dead, and Lieutenant Colonel Hefner was medevaced by helicopter to the Palomar Medical Center in Escondido, where he went into emergency chest surgery. He stabilized at the hospital but was still listed in serious condition after he emerged from surgery. Soon, military police arrived at the squadron and took Quintanilla into custody. They also seized a knife that he had with him. He was placed in pretrial confinement in the brig, and investigators began to process the scene. NCIS closed the base to all traffic for an hour while they searched for Quintanilla's car. This was about 3 years before a little button on the keys could signal a car's location most easily. At his pretrial confinement hearing, held to determine whether to release Quintanilla prior to his court-martial, prosecutors presented witness statements to justify keeping him locked up. There were 3 prosecutors on the case, but I only found information about 2 of them, a captain and a major. In order to avoid confusion, I'll do my best to refer to them by their rank. The court did refer to them by name, but these older cases didn't use initials as prevalently as the current courts. So I don't think it's necessarily an indictment on someone's behavior if their name's listed in these older cases. Though, to be frank, there was no love lost between the Navy Marine Corps Court of Criminal Appeals and the government trial team. In preparation for introducing the witness statements to the pretrial confinement hearing, the captain prosecuting the case presented copies of the witness statements to the initial review officer and to defense counsel. Then, the captain began reading the statements aloud in front of 5 or 6 media representatives. Defense counsel objected immediately to reading the statements out, arguing that the media would publish the substance of the statements and taint the jury pool. The media did, in fact, publish the substance of the statements, and during voir dire, every member of the potential panel revealed that they'd been exposed to media coverage of the shootings and investigation. Media coverage of the matter might lead potential jurors to form opinions separate from the trial, but I'd offer that these Marines, working on the base where the shooting took place, probably couldn't avoid coverage of the crime. Gunfire is not a shocking thing to hear on base. Marines have to qualify on the rifle and pistol each year. But it would be shocking to discover that a Marine attacked multiple Marines in broad daylight, killing one of them. Given the extensive media coverage on the case and publishing the substance of those witness statements, defense counsel moved to dismiss all charges based on prosecutorial misconduct. At the hearing on the motion, the captain testified for the government regarding his participation at that initial hearing. Then, he made the legal argument against the motion, incorporating argument about his testimony and behavior. During voir dire, counsel asked potential panel members about their ability to be impartial, and about whether they had any religious beliefs that might preclude them from fully considering the entire range of possible punishments. After all, the maximum allowable punishment for premeditated murder was a sentence to death. Sergeant Quintanilla pled not guilty to specifications of attempted unpremeditated murder, a violation of a general order by carrying and concealing a pistol, premeditated murder, aggravated assault, carrying a concealed weapon, communicating a threat, and obstructing justice. Quintanilla's defense seems to be that he was an alcoholic and that he showed up drunk to work that day, consumed by his family and financial problems. He claimed he went in to speak with Lieutenant Colonel Kidd and that he fired the shots by accident. I would have found it difficult to formulate a defense in this case, but I don't think sneaking in an illicit loaded weapon and firing it multiple times across multiple rooms at multiple people can reasonably be an accident. Misfires happen, but taking aim at 5 separate people and firing 4 shots isn't a misfire. In spite of the defense team's best efforts, the 12 members of his panel unanimously convicted Quintanilla. During the sentencing arguments, the major prosecuting the case, who handled the sentencing argument, climbed into the witness box and spoke about what Lieutenant Colonel Kidd would have said, what he would have testified to had he lived. And as he began to build his argument, he left the witness stand, got in Quintanilla's face and screamed, "You're a gang-banging, murdering animal who literally tore the heart out of a man, tore the heart out of a family, tore the heart out of the squadron, tore the heart out of the eagle on that flag over there." Over the rest of the major sentencing argument, he called Quintanilla a bad hombre once, an animal 3 times, referenced gang-banging twice, and drive-by shootings twice. This major was passionate in his argument about a terrible murder, but we can all agree that Quintanilla did not literally tear a man's heart out. We can agree that this was no drive-by shooting. Defense counsel objected to this sentencing argument, and the judge sustained the objection, giving the panel a curative instruction. Nevertheless, the panel sentenced Quintanilla to death, reduction to E1, and total forfeiture of pay and allowances. In 1998, after he was sentenced to death by lethal injection, Quintanilla moved to the Special Housing Unit at the Castle, Fort Leavenworth's death row. It's worth noting that the last time a Marine was executed was more than 200 years ago, in 1817, 81 years before Guam, Quintanilla's place of birth, even became a U.S. territory under the jurisdiction of the U.S. Navy. At the adjournment of the court-martial, prosecutors gave the bullet that pierced the CEO's chest back to him at his request. They gave Lieutenant Colonel Kidd's wife his ring back. The major prosecuting the case kept the knife seized from Quintanilla. And the captain kept the pistol used in the shooting, mounted it on a plaque, and hung it in his office when he left the Marine Corps and took a position as a deputy district attorney in Steamboat Springs, Colorado. The plaque included an inscription labeling both the major and the captain as Sureño Busters. In military death penalty cases, the Court of Appeal automatically reviews the sentence. It's not possible to waive or withdraw appellate review. Quintanilla's automatic appeal sat with the Appellate Defense Division for nearly 5 years before a brief was ever filed. He had 6 separate appellate defense counsel over that time. Each time a new appellate attorney entered an appearance, they had an obligation to read the record in its entirety in order to provide legal assistance. On appeal, Quintanilla argued that there was insufficient evidence to sustain his conviction for premeditated murder, which seemed surprising. The Navy Marine Corps Court of Criminal Appeals, the court that could conduct a factual sufficiency review, concluded that a reasonable fact finder could properly have concluded, beyond a reasonable doubt, that Quintanilla committed each of the offenses of which he was convicted. Further, this specific panel was also convinced beyond a reasonable doubt that Quintanilla did, in fact, premeditate this murder. However, the overwhelming evidence of guilt wasn't the only issue on appeal. The Navy Marine Corps Court of Criminal Appeals overturned both the findings and the sentence due to improperly challenging a member on voir dire. In 2005, 9 years after his crime, the Navy Marine Corps Court of Criminal Appeals ordered a rehearing. Although this voir dire error was sufficient to overturn the conviction and necessitate a new trial, the court wrote extensively on the issue of prosecutorial misconduct. They discussed prosecutorial misconduct so extensively so they could discourage a repetition of the misconduct moving forward. Prosecutorial misconduct is either action or inaction by a prosecutor in violation of some legal standard or norm. These standards and norms can be a constitutional provision, a statute, professional ethics norms, or, in the case of military prosecutors, a rule in the manual for courts-martial. The Navy Marine Corps Court of Criminal Appeals focused on the overall effect of counsel's conduct on the trial. If a prosecutor violates a legal norm, and if that violation impacts some substantial right, the court still has to evaluate whether or not the violation of that substantial right was harmless under all the circumstances of a particular case. The misconduct alone is not enough to overturn a conviction, and it's not enough to order a resentencing. The misconduct has to be prejudicial. The first incident of prosecutorial misconduct involved an ex parte communication. Ex parte communication is communication outside the presence of one of the parties. Judge advocates, the lawyers serving as military prosecutors and defense counsel, cannot communicate with a judge or other official without opposing counsel. If one side gives the other side advance notice, they can discuss administrative matters that have no bearing on the substance of the case. In Quintanilla's matter, the captain prosecuting the case had a substantive conversation about the case with the Article 32 investigation officer without any defense counsel. When the captain spoke with the investigation officer, the officer had all of the evidence and was preparing to make his recommendations. While the court found that the conversation had no impact on those recommendations, they also found that there was no lawful reason for the conversation in the first place. Prosecutors also sent 2 email messages to the prospective members of the panel. The emails were to communicate the trial schedule, but they weren't sent to the defense. And, as the prosecutor in question later explained to the Naval Justice School Capital Litigation course, he sent these emails with the goal of building rapport with the panel members. He wanted to establish a favorable opinion and trust from them. This was clearly ex parte communication, but it was strictly administrative, even if the prosecutor had devious motives. Neither ex parte communication had a prejudicial impact on Quintanilla's case. And remember the weird hearing on the motion to dismiss, where the captain acted as both witness and attorney? That captain violated the ethical rule against acting as an advocate and a witness in the same matter. The Navy Marine Corps Court of Criminal Appeals found that while his testimony was appropriate and necessary for the hearing on the motion to dismiss, there was no need for him to make legal arguments about his own testimony. There were 2 other prosecutors available to present the legal arguments. The court again concluded here that while this was an unwise decision and prosecutorial misconduct, it didn't result in any prejudice to Quintanilla's case. The court specifically noted that defense counsel didn't object at the time of the hearing, apparently concluding themselves that there was no prejudice to Quintanilla. But there were other problems with how the prosecutors, both the major and the captain, handled evidence after the court-martial. Namely, they gave a bunch of it away before the appellate review could be final. The bullet, the ring, the knife, and the gun were recovered and returned to NCIS upon discovering what happened to each of them. I think there is space for empathy, giving a widow her husband's ring back. I think there's at least explanation for giving the surviving commanding officer the bullet that nearly killed him. But even in my most generous mood, I cannot come up with an acceptable explanation for the major and the captain holding on to the knife and the pistol as trophies of their accomplishments. It was illegal for the prosecutors to take the evidence without authority, especially in a death penalty case. A death penalty case necessarily has many levels of review and takes years, if not decades, to become final. This misstep, however, still didn't prejudice Quintanilla's case. Their actions didn't impact either the finding or the sentence. The sentencing argument, however, was where the appellate court felt the most spicy about prosecutorial misconduct. The sentencing argument the major made was incendiary, climbing into the witness box to pretend to testify as the decedent and calling the defendant a gang-banging, murdering animal was a lot. It didn't help that the major took this sentencing argument on a roadshow. He made multiple presentations to the Naval Justice School Government Capital Litigation course regarding his sentencing argument. There aren't a ton of capital cases in the military, so hearing directly from someone who litigated a contested case is valuable for other prosecutors. This major, apparently a natural showman, described starting his sentencing argument and moving into his, quote, objectionable stuff, then spoke about taking a seat on the witness stand, and described that action as highly objectionable. He knew his sentencing argument was very problematic, and that it violated ethics canons. The appellate court described the major's conduct and language as overbearing, intemperate, and deliberate. They identified that he intended to inflame passions and prejudices. He called Quintanilla a bad hombre, which is almost certainly an unnecessary reference to Quintanilla's race. It probably wouldn't have been inappropriate to call Quintanilla a bad man, but the major made a decision to bring race into it. There's also no evidence of Quintanilla being involved in either gang-banging or drive-by shootings, which is why the judge sustained the objection and made a curative instruction to the panel. The appellate court presumed that the members did indeed follow the curative instructions in their deliberations, and because of that, they had to conclude that the references had no impact on the sentence the panel handed down. But behaving in this way jeopardized the fairness of the sentencing phase, something the court called an affront to the principles of justice and fair play. The court declared that the prosecutor's misconduct jeopardized the integrity of the trial proceedings and besmirched the military justice system in the United States Marine Corps. They offered this analysis and feedback as a cautionary tale for other prosecutors, like all of the prosecutors who took that capital litigation course. Here, the prosecutor's actions hadn't prejudiced Quintanilla's court-martial, but other prosecutors might not get so lucky. The Navy Marine Corps Court of Criminal Appeals had already vacated the conviction and ordered a new trial. A dissenting opinion suggested that the appropriate remedy was to order just a new sentencing hearing and to maintain a finding of guilt. This dissenting opinion is ultimately where the next appellate court, the Court of Appeals for the Armed Forces, came down. They determined the court-martial judge did not abuse his discretion in granting the prosecution's challenge to a panel member, and in 2006 ordered just a resentencing. In 2010, Jessie Quintanilla was sentenced a second time to life in prison, with the possibility of parole. In between when CAF ordered a sentencing rehearing and when he received his new sentence, military doctors diagnosed Quintanilla with paranoid schizophrenia and determined that he was unable to participate and assist in his own defense. Quintanilla's mental health stabilized with treatment and medication, and when he was found competent to participate again, the sentencing resumed. In exchange for taking the death penalty off the table, Quintanilla waived his right to further appeals of his conviction. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com. Join me next time, and together we'll resist the urge to go AWOL. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, endorsed, or authorized by the Department of Defense.